Let me welcome you, please, to the panel session discussing how emergencies impact on the rule of law and accountability of government agencies for their actions during the emergency period. So the question of emergency powers and their relationship to the ideal of rule of law and basic principles of government accountability raises fundamental questions about the relationship between legality and emergencies. And should emergency powers ever be imagined as existing outside the requirements of legality? So in this panel, we're fortunate to have a set of excellent papers that discuss these issues from a range of perspectives and in relation to several different countries, Japan, Vietnam, Ireland, and Australia. I will not introduce the speakers in detail, but you'll find their biographical details in the conference website along with their paper, and I encourage you to look at their papers when you have an opportunity. Let me first summarise the papers. Professor Nishikawa's paper discusses how historical circumstances have produced some paradoxes in Japan's legal system for handling emergencies such as the COVID-19 pandemic, with one of the particular features being the successful and widespread use of voluntary administrative instructions that were not backed up by sanctions. This paper shows how enforcement of legal powers was supported and made more effective by the exercise of extra-legal and social and economic forces. Professor Na's paper tests the response to COVID-19 pandemic against the principles of rule of law. This paper evaluates the different pandemic control powers exercised to restrict freedom of movement and its relationship to the rule of law. Professor Tuan's paper examines one of the most controversial legal questions relating to emergency powers. That is, whether emergency powers must be exercised within the bounds of law or whether the ordinary principles of legality do not apply. This paper considers the relationship between emergency powers and protection of human rights, and it notes that emergencies, local powers are often re-centralised and exercised by central authorities. And I would just note that this is actually an interesting theme that's emerging, where we see in some countries that during an emergency, central powers are exercised by local authorities, but in other circumstances, local powers are re-centralised to be exercised by central authorities. Dr. O'Brien's paper presents the idea that a thick accountability mechanism is needed in the time of COVID-19. By thick, she means mechanisms which offer a more substantial form of wide-ranging inquiry into the causes and consequences of the COVID-19 crisis. She presents several such mechanisms which are currently in use in the Australian system. The first is the Parliamentary Committee inquisitorial style inquiries, and the second are systems-level inquiries by other integrity branch actors such as the Ombudsman and Auditor General. Professor Donson's paper examines issues of governance by a caretaker government, that is the Irish government, during the COVID-19 pandemic and its impact on the proper functioning of Parliament. So my questions to each panellist, if you wouldn't mind answering them in 3 minutes, please, are as follows. The first question for Professor Nishikawa. In your paper, Japanese Response to the COVID-19 Pandemic, Politics and Emergency Powers, Human Rights and the Rule of Law, you suggest that reliance on extra legal mechanisms of social and economic force to supplement administrative and coercive measures to address the pandemic might have been effective, but that they also raise questions about structural weakness in the rule of law in Japan. Would you elaborate on this point, please?
Thank you, Chair. This is a point that I could not actually address deeply in the article because the article already reaches 8,000 words. But I addressed extra-legal way of enforcing government policy in Japanese action to counter COVID-19. And I refer to administrative guidance that also include similar informal action taken by administrative agency without legally binding force that are intended to influence the actions of private party in order to realize some administrative aim. And I think although sometimes such extra legal way bring positive outcome, I think we cannot deny it include an element of an abuse of executive power and also acting outside of the law. And this is routine in Japan, although such administrative guidance are undertaken in other countries as well. But I think the degree and frequency of it is outstanding in Japan. And for me, the rule of law, one of the important elements of the rule of law is to limit government power, executive power, particularly country Japan, which even in emergency situation, ordinary laws and constitutions are effective. So that is why the extra-legal way of enforcing government policy, as we see in COVID-19, was also the problem because it enforced government policy, government power outside of the law.
Mm-hmm.
And usually the general attitude of the courts, at least dealing with cases of administrative guidance involving in the central government, has been either to uphold the legality of the guidance or to avoid directly ruling on the issue. So in such practices, I see certain weaknesses of Japan's rule of law. Does it answer to your question?
Yes, thank you very much. It seems that the Japanese system is quite distinctive in that it's different from other countries which use coercive powers very quickly, and Japan will use coercive powers very slowly. It provides a very interesting contrast. So thank you very much.
Thank you very much.
For that very interesting discussion. So my next question is for Professor Dam Minh Tuan from Vietnam National University. In your paper, Emergency Powers, Human Rights and Rule of Law, you note that emergencies challenge a number of core principles of legality, including which agencies should exercise power and to what extent it is permissible to derogate from human rights in exercising these powers. Could you tell us something more about these issues in Vietnam? Is Professor Tuan here?
Yes, I'm here. Yeah.
Oh, good to see you.
Yeah. Hi, everyone. Hi, Professor Sarah. Thank you for the chair, and thank you very much for your comments and question. And in my papers, as you said, that emergency challenges a number of core principles of legality, including the exercise of powers and derogation from human rights. And the first, in the exercise of emergency powers, Vietnamese law empowers the Prime Minister to decide the number of special measures. Among them, many aim to restrict fundamental rights, such as right to demonstration, right to transportation, right to assembly, right to association. Arresting emergency law violators is carried out in special orders. The Prime Minister has the right to request the President of Vietnam to mobilize armed force in the areas of with emergencies. In the period of COVID-19 pandemic, Vietnam has not declared a state of emergency, but in fact, the Prime Minister has issued the Directive 16 on social distancing with many special emergency measures. The granting of special powers to the Prime Minister, in my opinion, is similar to other international experience studied in my research. About local authorities, it's interesting that some local authorities have provided their own policy to prohibit or restrict human rights, especially right of transportation. Their policy was very controversial with the supporters and critics. In my opinion, the local authorities' policies are unconstitutional and illegal. Concerning the authority to emergency proclamation, is different from Vietnam to other countries is that the power to declare, the power to decide the proclamation of emergency belongs to the National Standing Committee, not to the National Assembly. As I understand, in case of emergency, convening the Standing Committee of the National Assembly is easier and more convenient. And after the decision of the Standing Committee is issued, the President will proclaim the state of emergencies. The second point, the second issue in terms of derogation from human rights, there's no specific legal provision on the derogation from human rights in Vietnam, in Vietnamese legal system. The Constitution, the ordinance on the state of emergency, and other laws only provide limitations on rights, not derogation from human rights. In my opinion, Vietnamese lawmakers may consider derogation from human rights is a specific kind of human rights limitation. However, in my opinion, and in my research and other research I have done, it's very necessary to clarify these two different terms, especially the derogation from human rights in the state of emergency. Yes, that's my answer to your question. Yeah, thank you very much again. Thank you.
Thank you very much. You know, I can see that throughout this panel and other panels, there are a number of very important and interesting questions arising about ideas about proportionality, about when is it permissible morally and legally to derogate from international human rights. And now we have another idea emerging, which I think is also very important, which is what is the role of the citizens? To what extent should citizens be empowered to bear some of the regulatory burden in this COVID time or at any stage? And to what extent can they share the regulatory burden with state agencies? Which is a question that comes up all the time, but very particularly now. So thank you very much for your answer, which I think raises a number of really important issues for us to think about. So now I'll turn a question to Dr. Paula O'Brien from Melbourne Law School. In your paper, Thick Accountability Mechanisms and Public Health Emergency Powers under COVID-19, you argue that courts are not the best forum for ensuring accountability in relation to legislation and executive conduct during COVID-19. You prefer a range of other inquiry-style mechanisms. What do you see as the shortcomings of judicial review? Are there circumstances when it would be preferable to the mechanisms you highlight? Do you think review by courts and other inquiry-style mechanisms can complement each other to ensure accountability? So over to you, Paula.
Thanks very much, Professor Biddulph. Excuse me, everyone. In the Australian system, like in most of the systems that we're talking about in the conference, review by the courts is really the ultimate mechanism for deciding on the lawfulness of legislative and executive conduct. And I consider it to be a necessary mechanism in a society committed to the rule of law. But in the Australian system, the courts have a very limited role, and that's because we have quite a strong separation of powers doctrine operating in Australia. So courts in Australia review legislation for their consistency with the Constitution, and they also review executive decisions and actions for their compliance with law. And as Professor Lieberman flagged earlier, there's very limited review for consistency with human rights standards. Now, this is an exceptionally important role for the courts. It's a critical role in our society. And of course, one of the strengths of using the courts is that they make orders that are binding, and we have a practice of governments in Australia respecting and following the orders made by courts, which is not something to be taken for granted.
Mhm.
But my argument is partly that in times of crisis like the one we're in now, we need an evaluation of not just whether governments are governing lawfully, but also whether a government has governed well. And by well, I mean things like, have the actions taken by government been effective? Have actions taken by government been efficient? Have the actions taken by government been fair? Have they been inclusive? Have they ensured protection of vulnerable groups in society? So we know that in pandemics and times of crisis, groups who are already vulnerable face greater hardship. So the courts in Australia can't address these types of questions because they don't have the inquisitorial type powers that are really necessary to dig in and really deeply evaluate how government is acting. And so that's why I propose and support the range of a use of a number of mechanisms. And I do see these mechanisms, so parliamentary committees, ombudsman, which sometimes in different countries are called counsel for grievances, and auditors general. And I see these mechanisms as offering a complementary set of mechanisms to the courts to allow for more comprehensive, deeper and more exacting review of government's conduct. And I really see the courts and these mechanisms working together to try and produce a culture of what I call good government, to apply in times of crisis, but to apply at all other times also. So thanks, Professor Biddulph.
Oh, thank you very much. And I think another theme that we see emerging is that the COVID-19 crisis highlights a number of structural issues which may be acute during this period, but actually exist all the time, and help us to identify and to focus on those. So thank you very much for that answer. Let me turn now, please, to Professor Fiona Donson from University College Cork. I also noticed that Professor Na is in the room, so I'll ask her to answer after Professor Donson. So, in your paper, COVID-19 Emergency Measures in Ireland, Achieving Accountability and Protecting Rights, you discuss the constitutional and legal difficulties faced by the Irish legislature in adapting to the physical distancing restrictions imposed during the COVID-19 pandemic response. Could you tell us more about the impact of pandemic-related restrictions on the exercise of public power more generally and ensuring government accountability? So over to you.
Thank you, Professor Biddulph. And I think my paper and what I'm going to say now is along the lines of what Professor O'Brien was talking about in terms of the structural difficulties that are already there, and how this has shone a light. So obviously in Ireland, as my paper shows, there's a particular coming together of circumstances, which is that we had an election shortly before the pandemic hit. But we exist in a situation where we already have weak accountability structures, and that much of that accountability mechanism is focused on our parliament. And given that, therefore, we were in a position of having no elected government when the pandemic arrived in the shores of Ireland, that emphasis on parliamentary accountability, and even in that context, a weak accountability structure was really exposed for the difficulty that we have and the lack of alternative structures. We also, I should say, have a heavy reliance on judicial review, but Professor O'Brien has already kind of illustrated that to some extent in an alternative context. So a very clear example of how that panned out, I suppose, bringing together the constitutional and the legal issues, was that because we had, at the time of the pandemic becoming an issue, a caretaker government, but also our second chamber was due to be dissolved and re-elected. The emergency legislation had to be passed at very, very short notice. And this is probably one, and I didn't really adequately address it in the paper. This emergency legislation was passed with virtually no debate because of the need for speed, because we only had a matter of days. And that emergency legislation therefore had limited oversight and handed a great deal of power to the executive, a great deal of power provided to particularly to the Department of Health and the Minister for Health, and for what was established as a public health emergency team, which has absolutely no oversight in relation to how it operates. And it's really shone a light on how such a team from the health context needs to have clear oversight mechanisms within it. And we've been rather left with the media pushing from that side to provide kind of critical reflection, combined, I suppose, with the one good element that's being developed, which is the special committee, the parliamentary special committee that was established to look at COVID-19 issues. But those have both focused to some extent on emergency or crisis scenarios, and has left to some extent the general oversight of what's been going on undealt with. And I think in the early days of the government responding, things have been handled relatively well. So the government, because it had a limited mandate, it really sought to kind of take a positive response. But I think as we're looking now forward into moving into a less crisis situation and to kind of normalizing, I think now we're seeing the gaps in those accountability structures where people are seeking to have questions answered and really struggling to find ways. The other real crisis we're faced with is that our second chamber is not clearly constitutionally constituted now. And as we move into a situation of needing new legislation, we don't appear to have a second chamber that can help do that. We actually have a court case due next week that will consider whether or not our second chamber is constitutionally created, and so therefore whether new legislation can be brought forward. So I think it's really illustrated that the full-on crisis of our structures that we need to have a mature discussion about at the end of this.
Yeah, thank you very much. Isn't it interesting how a crisis shines a spotlight on gaps that might have just sat there quietly and nobody really paid much attention until something had to be done. So thank you very much for that answer. And now I'm delighted we found Professor Nha. And so let me ask you my question. In your paper, COVID-19 Pandemic and the Emergency Law in the Rule of Law, you evaluate measures taken to control the pandemic in the context of the requirements of rule of law. You note that while government agencies are closed, most officials are working from home, with the exception of the courts, where open trials are subject to restrictions. Could you tell us some more about the court closures and other pandemic measures and what they might tell us about the tensions in complying with basic rule of law principles in a time of pandemic? Over to you.
Thank you for the question. Hello, everyone. I'm apologize because last time I forget to turn on my microphone.
That's okay.
Techniques always problem with me. For the question, I from my voice I can answer. As you know, Vietnam is a country has soon meet I think it's a strict meet to resolve COVID-19 pandemic. And for the close cost of Chief of Justice Supreme Court, the Chief of the Justice Supreme Court launched direction number two to prevent of the control COVID-19 and people caught According to from 10 of March to end of March 2020, the court will not open court hearing except for case for which the settlement term had expired. I think you have a difficult question for me. From my private points, I think that one hand, it is a good opportunity to control spread of the COVID-19. So, another hand, it is very difficult for the people relevant the case. So now, because of the part of on, I think human rights and citizens' rights may maybe it's limited because they want to their case has resolved quickly because it is relevant of their right. So because the court is closed, it is not resolved quickly. For example, in the family case, some people want to divorce because of courts are closed. It is they can resolve in this time. Actually, after following the decision too, Chief of Justice Supreme Court launches another document for the child special season continue closed court until the end of the July. It is. I think it's a very difficult for the people on the family care or chase case, and actually it's a criminal case. It is not good because of, according to the Constitution 2013 regulates everybody has the courts quickly to protect their right. Yes, you know, it is a regulation 30 Article 30 about Constitution 2013. You know.
Yeah, thank you.
Yeah,
thank you for that
choice.
very interesting answer. Thank you. I think that it's true to say that open justice and the timely administration of justice by the courts has been challenged in every jurisdiction, and different jurisdictions have taken different actions. So, for example, the courts in Victoria moved very quickly to online hearing of some cases, and also there were changes to the rules of bail to enable some people who should not be kept in pre-trial detention to be released. And I think that every jurisdiction has certainly struggled with how to deal with this situation. So thank you very much for those very thoughtful comments.
Thank you for the comments. Yes.
I wonder if now we might move to the questions, and I'll come back to you because I think there is another question for you. We have now 20 minutes for questions. So let me ask some questions and we'll come back to talk about this issue with you again in a few minutes when we have some time. So thank you very much. So now moving to the questions, I see that there are a lot of questions and some answers already in the chat. So I'm trying my best to work my way through which questions aren't answered. If I miss yours, then please send me a note. So the first question now to Dr. Fiona Donson. Thank you very much for your paper. Please, could you clarify the following point? The claim of rights activists to challenge the regulations enacted to deal with COVID-19 was dismissed by the High Court. Could they appeal this decision of the High Court, or do they have to wait from the oversight of the Oireachtas? Is that how I say it?
The Oireachtas.
Oireachtas.
Nearly there. That was very good. Very good. And a good question. Yes, the application from the activists was very clearly dismissed, not least because it was actually a very poorly argued case, and a lot of us, although we enjoyed the court judgment, which was very dismissive, we felt that any potential argument that could have been made was rather lost in the fact that the applicants were so weak. They self-represented, but they also have a bit of a reputation for being, shall we say, difficult or for challenging the state position. They have already lodged an appeal with the Court of Appeal, although the general view amongst the legal community is that they have very little chance of winning that, and costs were actually ordered against them a couple of weeks ago. In a case like this, given that it's a public interest case, is unusual and illustrates the weakness of the case. The other element to this is that these are activists who would not regard the Oireachtas or any kind of official body as being able to put their position, because they would regard any officials, any public representatives, as being kind of biased against them. So it's rather unfortunate that the one case we've seen develop has been brought by people who would regard this as a platform for their particular political views, rather than it being an account. It's not about accountability. It's about platforming them and their politics. We will see what happens in the case next week in relation to the constitutional question about the organisation of our Shanad, our second chamber. That's an altogether different kind of case. But thank you for the question.
Yeah, thank you very much. Now I'll move on to the next question, which is from Darius Lee, and it's addressed to both Professor Nishikawa and to Paula. So I'll read the question. What role, if any, does local culture, including constitutional culture, play in pandemic response and accountability mechanisms? And the second part of that is, should accountability mechanisms be tailored according to differences in culture and constitutional culture, and if so, how? So might I first turn to Professor Nishikawa, and
Yes.
then after your response, I'll ask Paula to say something. Thank you.
Yes, thank you very much for this question. It is actually difficult to answer, but I tried to do my best. Yes, in my article, I actually point out Japanese people tend to not to resort to law and try to resolve many issues politically, socially, in a very extra-legal way. And I may call it the culture, political culture, or social culture, partly because Japanese law is complex. It includes both foreign influence and indigenous elements. Mm-hmm. And many issues are not actually legalized, codified into law. So when something happened, like emergency situation, Constitution never provide any measures. In that case, again, rather than purely resorting permanent law, it tried to resolve it outside legal way. So that is why if some people from other countries see the situation, it may be called a culture, Japanese culture. So, but for Japanese, it is one way to handle the situation that law cannot provide proper procedures. But even some element that exists in law, some people prefer to resolve it politically, socially, rather than legally. So I would say, well, there's such culture that prefer political social solution than legal solution.
Yes.
But again, when talking about accountability, okay, this is a big question. And nowadays, thanks for the development of social media, many issues are reviewed, not formal way, but informal way. So that is why I think government is gradually more open to explain their policy and how they came to introduce this policy and law. And it's in a process of changing the culture itself. And also the interpretation and discourse of certain laws in Japan is usually always divided different views. And that is why I think when deadlock happens in terms of interpretation, discourse of certain law, they try to resolve it by using political measures or social measures. Can this answer to your question?
Thank you. I think it raises a number of really very important issues for us to consider. So sometimes people will explain different practices by using the term culture. And I think your answer alerts us to the idea that we need to be sensitive to the fact that what might be called culture actually arises because the system is designed in a certain way, and people are finding practical ways to deal with problems that actually confront them in person. And also, I work on China, and so often we see what's called culture sometimes relates to habits of power, which are very sticky. The government is accustomed to working in a certain way, and it's hard for that to change. So I think that your answer actually problematizes, if you like, what we call culture, what actually should be attributed to the way in which the system is structured, and to habits of power. So thank you very much for your answer.
Thank you very much.
Might I now turn to Paula to answer that question from maybe an Australian perspective?
Thank you, Sarah, and thanks, Professor Lee, for the question. The question, particularly the first question, really goes to the heart of one of the strong responses I had to the conference yesterday, which was realizing how much our experience of the pandemic is shaped by our local contexts. And, the virus itself, it has an objective reality. It's a scientific fact, but actually our experience of the virus is very much shaped by the systems in which we find ourselves. And I feel like that's what we've been hearing across the conference. People from different countries are experiencing the virus quite differently depending on, and it could be called culture, but I really agree with Sarah that to a large extent, it actually depends on our political and legal systems, the political and legal systems in which we find ourselves. And part of the reason for that, from my perspective, is that the government's capacity to respond to the pandemic, so you raised this in your question, is very much shaped by the political and legal culture in that particular country. So what measures a government can take are very much shaped by political and legal power, political and legal responsibilities, political and legal limits on power. The other thing that I think that the local context does is that shapes the government's response is depending on how a government understands that its population will respond to measures, it will do certain things. So if you have a population who will tend to go along with what government says, has high levels of trust in government, then the government can do certain things. In systems where there isn't that level of trust in government, then the government has to do different things or do them in different ways. So I think your question really is getting to the heart, for me, of, in some ways, what we're hearing in the conference. Just on the question of accountability mechanisms, I think it's absolutely vital that accountability mechanisms are responsive to the culture in the particular country. And I think there's two reasons for that. One is what accountability means, I think, differs by country. So what are the standards to which we are holding government? So what are the types of legitimacy that apply in different contexts? And secondly, mechanisms need to be ones that the community can use, that they can access, that they can understand. And so I think it's really vital that accountability mechanisms take into account the local culture, and so that could be the political, legal, but also some kind of broader social culture and the way that community operates. So I think they're great questions. Thank you very much.
Thank you very much for that answer. It's I think this is a very interesting conversation. Now, I thank you, Fiona, for answering that question, your second question, separately, because I wanted to share the questions around a little bit. So I see that you've addressed one question on the chat. So that enables me now to turn to Professor Tuan. And here is the question: whether or not emergency powers should be constitutionalized, and whether or not it should have a derogation provision in case of an emergency in the Constitution itself.
That's
Yes.
a good. Oh, sorry.
For my question.
Yeah.
Oh,
yeah,
sorry.
Yeah.
Thank you for this very interesting and crucial questions for my paper. The first, whether or not emergency power should be constitutionalized. I think that is quite challenging to constitutionalize emergency powers, because emergencies are often exceptional and discretionary, and it's true that emergencies are unpredictable. So that's why a few constitutions in the world have provisions on emergency powers provisions, but many others regulate them in the form of laws and acts. And even in each emergency, it should have a specific law, such as the case of Japan presented yesterday. For each emergency, Japan adopt a specific act of emergency. And for the second question, whether or not it should have a derogation provision in the case of emergency in the Constitution, I think that the Constitution should have a derogation provision, because the derogation from human rights is one of the policies that affect most human rights. So that's very serious for human rights. So I think that a Constitution should have derogation provisions. So I have learned that some constitutions have a derogation provisions in the Constitution. So in Vietnam, I think that in the future we should discuss about this and provide in the Constitution in the future. Yeah, thank you very much.
Thank you very much. Fiona, can I just turn back to you? I'm sorry, I just cut you off.
No, sorry, you're fine.
Did you want to add something?
No, I mean, I think the question was well answered. I mean, I certainly think in the Irish context, we have no provision for emergency powers along these lines, and I think you have difficulties in how you know, depending on the question of amending constitutions and the danger of taking a particular scenario such as this and adapting constitutions particularly quickly in response to those. There's a lot of reflection that needs to go on in terms of what we should do with the Constitution. And in many countries, that's become so embedded and so difficult to change subsequently that you can amend constitutions in ways that become unworkable or difficult. And we have to think of the balance between and has already been said, the constitutional level, the legislative level, and then the more structural levels. Sorry, that's all.
No, thank you. Thank you very much. Now, actually, maybe what we can do is because we've got only 1 minute left until the end of our session, and I feel highly chastened because yesterday I went 4 minutes over. So I wonder if maybe we should finish this session. In parallel, I've been making some notes about some of the important themes that have arisen that I hope that we might talk in the general discussion later. And so Let me now thank you all, to the chairs and to the panelists for your very interesting reflections, for your excellent work.